Okay, hi James, apologies, my camera on my laptop has just stopped working, so this is just filming on my phone. But my presentation will address the following questions. Is the rule of law in jeopardy in Japan? What other desiderata might the legal system be prioritising? Firstly, the rule of law is broadly understood to require that power be exercised through established laws, not personal discretion. It implies equality before the law, legal certainty, access to justice, and an independent judiciary. In Western liberal democracies, it is typically tied to constitutionalism, judicial independence, and the protection of individual rights. However, evaluating Japan through this lens without critical qualification risks analytical distortion. Instead, I argue that Japan's legal system reflects a managed legality model in which institutional incentives, bureaucratic coordination, and socio-normative priorities such as harmony and consensus deliberately constrain the judiciary's role as a rights-enforcing check on executive power. Thus, the rule of law in Japan is not absent, but is practically misaligned and constricted. I will argue that Japan's difficulty lies in the systematic under-enforcement and functionally reposes rather than overt authoritarianism. So, Japan's 1947 constitution, drafted under Allied occupation, strongly enshrines liberal democratic principles, including Article 14's guarantee of equality before the law and Article 31's due process protections. It also grants the Supreme Court the power of judicial review under Article 81. However, doctrinal supremacy exists in tension with institutional passivity. So the Supreme Court has only invalidated legislation 11 times in its 75 years. Compare this to Germany's Federal Constitutional Court, where they have squashed over 600 rulings. This discrepancy is not due to an absence of unconstitutional laws or cultural reluctance. It instead reflects a deeply embedded institutional and political culture of judicial restraint. This includes the Supreme Court's General Secretariat, which administers career control mechanisms. It includes an embedded norm of non-interventionism, reinforced through their hierarchical discipline. And it also includes a court culture oriented towards policy coordination, not constitutional confrontation. This indicates a failure of legal norms, but institutional engineering that reposes judicial review as symbolic rather than a substantive safeguard. The court rarely hears politically sensitive constitutional questions, and when it does, it often declines and neglects to intervene in this sector. So this raises a fundamental question: what good is constitutional supremacy if the judiciary refuses to enforce it? Now, one of the most illustrative cases of this is the Sonakawa case in 1959, where this challenged the constitutionality of the US-Japan Security Treaty. Despite straightforward questions under Article 9, the so-called peace clause in the peace constitution, the court deferred this ruling and stated that national security matters are non-judiciable political questions. Now, scholars like Shigenori Matsui and Craig Martin have attributed this to a precedential insulation to factors such as judicial promotions, which are contingent on conformity rather than their own merit, and judges face horizontal transfers or stagnation from dissenting from established lines. The judiciary is structurally insulated from popular pressures, and it's not there to serve independence, but to maintain an elite coherence. Now, this wasn't an isolated decision, but it was symbolic of a broader pattern in the judiciary. Japanese courts frequently invoke the political question, doctrine, or procedural technicalities to avoid constitutional confrontation, especially when it comes to matters of defence, electoral mal-apportionment, and administrative discretion. Judges who make bold rulings risk career stagnation, creating a judiciary that is, while technically independent, it's essentially institutionally subordinate. Furthermore, Japan's criminal justice system continues to draw international criticism for what is known as hostage justice. And this is when suspects can be detained for up to 23 days without formal charges, and extensions can be sought consecutively by rearresting suspects on similar charges. During this time, they can be interrogated without a lawyer present, and often this leads to false or coerced confessions. The case of Carlos Ghosn, the former Nissan CEO, brought international scrutiny to this system. Detained for over 100 days and subjected to multiple rearrests, his case highlighted how legal procedure can be weaponized to extract compliance rather than uphold justice itself. The system's procedural rigidity is not accidental, as it enables prosecutorial dominance and institutional closure against judicial scrutiny. The United Nations Human Rights Council has criticised Japan's prolonged detention practices and reliance on confessions as violations of international human rights norms, notably the International Convention on Civil and Political Rights, to which Japan is a signatory. But domestic courts have rarely treated these concerns as grounds for substantive intervention. Next, we must consider Japan's legal culture to understand why this passive approach persists. So, rooted in Confucian values, Japanese society traditionally emphasizes social harmony, hierarchy, and group consensus. Litigation is often seen as socially disruptive, and the adversarial system is treated with suspicion. Japan's remarkably low litigation rates reflect this cultural aversion to legal confrontation. Rather than seeking recourse through courts, disputes are often handled via administrative guidance, so this is through mediation or settlement. In other words, the law exists because it is usually kept in the background to maintain social order. Frank Upham famously coined the term bureaucratic informalism to describe this. Law is essentially subordinate to governance, and legal institutions support instead of constraining or keeping in check state authority. So these values function as a reinforcement for institutional designs, favouring elite administrative discretion over adversarial practices and judiciary systems. Next, attempts to reform the system were made in the early 2000s, with the Justice System Reform Council proposing wide-ranging changes, including expanding legal education, improving access to support for civil litigants, and introducing the lay judge system for severe criminal cases. These measures were intended to make the law more visible, accessible, and accountable. However, many critics argue that this has had a very limited impact practically. Prosecutors continue to dominate criminal proceedings, conviction rates remain at a close 99.9%, and the system still relies heavily on confession-based policing. Further, legal education reform has focused on producing commercial lawyers, not public interest litigants, and access to justice remains limited in rural and marginalised areas of Japan. So practically, procedural reforms have been implemented, however, they lack action in society. So what other desiderata might the legal system be prioritising? When we ask this question of the rule of law, we consider it to be in jeopardy in Japan, and this prompts a more foundational question. If the legal system is not prioritising liberal constitutionalism, what is it prioritising instead? So one core priority is its administrative rationality, so maintaining a stable and predictable technocratic governance structure. Japan's post-war legal system has long served the administrative state, with ministries like the Ministry of Economy, Trade and Industry and the Ministry of Finance shaping economic and social policy through administrative guidance. This bureaucratic legalism often means informal norms and procedural rules override substantive justice. Frank Upham argues that Japanese governance is rooted in a rule of law rather than a rule by law rather than a rule of law. The legal system becomes a tool of managerial efficiency, enabling bureaucrats to guide outcomes without judicial interference. Next, another key desideratum is economic instrumentalism, which involves using legal structures to advance market efficiency and national competitiveness rather than enforce justice. So this means that this is a developmental state model where legal reforms are often market-facing rather than individual right-facing. For instance, things like corporation law, arbitration, and IP protection have been expanded to attract foreign investors. And legal education reform focuses on providing commercially capable lawyers, not public defenders. So this means that commercial law has expanded while public law remains stagnant. Next, we've got a third priority is also the preservation of social harmony. A normative value that is deeply rooted in Japan's political and cultural orientation. Conflict especially through litigation, is often seen as socially destabilizing. Therefore, the legal system operates to discourage confrontation and rather encourages consensus. Courts are reluctant to issue decisions that might disrupt the status quo or embarrass public officials. Next, we also have, lastly, the Japanese judiciary prioritizes institutional loyalty and bureaucratic discipline over individual judicial autonomy. Judges are civil servants managed by the Supreme Court Secretariat, controlling appointment, promotions, and transfers. This creates an environment where controversial rulings, particularly with those against the government, can damage one's career. So therefore, judges are encouraged to be cautious, deferential, and consistent with past precedents, which cultivates what legal scholars consider an invisible constitution, a set of unwritten norms and institutional behaviours that dominate over the formal text of the constitution. So to conclude, the rule of law is not in imminent collapse, but is rather stagnating. The legal system upholds order and predictability, but these achievements come at a cost, with limited judicial independence, weak constitutional enforcement, and the tendency to subordinate law to protect bureaucratic or economic objectives. In this way, the rule of law in Japan is procedurally sound, but substantively restrained. Laws are followed, but their deeper purpose, protecting individual civil rights and limiting state power, is marginalised. The jeopardy for Japan lies in its conformity, a system so committed to stability, predictability, and consensus to the extent that it excludes adversarialism, rights claiming, and substantive accountability. Going forward, questions of legal reform in Japan must grapple with institutional capacity and cultural expectations, political inertia, and entrenched administrative traditions. Only by confronting these can Japan move closer to a system where the rule of law is respected in form and also realised in practice. Thank you so much.